Now, Vihiga Senator Godfrey Osotsi has written to the Speaker of the Senate seeking to introduce a bill to review the Constitution to provide for the right of the citizens to review a final decision by the Supreme Court through a referendum. Cases such as the Supreme Court ruling on LGBTQ and the Supreme Court verdict on the 2022 presidential petition are proposed to be taken to be decided by the public.
The proposed bill by Vihiga Senator Godfrey Osotsi is pegged on Article 1 of the Constitution, which states that all sovereign power belongs to the people of Kenya and that the people may exercise their sovereign power, either directly or through their democratically elected representatives. Osotsi goes ahead to propose that where the people of Kenya are dissatisfied by a decision of the Supreme Court, they should be granted power to review that decision, especially in regard to a presidential election or petition, interpretation and application of the Bill of Rights, especially in regards to family values of the nation.
The courts have delegated powers. Parliament has delegated powers. The executive has delegated powers. So what happens if the Supreme Court abuses those delegated powers? Do we stop there or we move on? At the moment, we're having a discussion in Israel over the same thing. That should the Supreme Court be the final arbiter in a matter, or we can have other avenues of appeal.
The current constitutional framework allows any citizen dissatisfied by the executive bills passed by Parliament to approach the judiciary for review. However, no rights of review exist with regards to decisions made by the Supreme Court, which is the final ruling after the appeal stage.
That is why I proposed in my proposed amendment that on matters of national importance like presidential election, petition, and Bill of Rights, interpretation of Bill of Rights, particularly on matters to do with family values. Whenever the Supreme Court makes a decision on that, the aggrieved parties have the option of triggering a referendum. Because that is provided for in law, that the sovereign powers rest in the people of Kenya.
The proposed bill seeks to give that provision to Kenyans, in that a person seeking to review the decision of the Supreme Court shall be required to demonstrate that level of dissatisfaction by collecting at least 2 million signatures of at least 2 million Kenyans in support of the move, in order to prompt the Independent Electoral and Boundaries Commission to conduct a referendum on the matter.
If the people of Kenya are unhappy over a decision made by the Supreme Court, they should be allowed to go to a referendum to test that decision in the public, so that if the public says they agree with the decision of the Supreme Court, well and good. But if the public says they disagree, then it means the public decision takes precedent.
Melita Oletenges, NTV.